distinguished guests, ladies and gentlemen, please take a seat. Good morning. I think we will have some fun today. This is a seminar to commemorate partly 200 years of the Norwegian Constitution. We will be kicking off with the Ambassador Katja's remarks, but before that I want to say that the reason we're having this seminar today is, yes, to celebrate Norway's long-standing famous constitution, but also to talk about Thai politics. This is a good way for us to segue into constitutionalism in Thailand. At the university, we haven't had many activities in recent months because of the various activities of the protests and so on. So we are happy to try to have more forums, seminars, and I hope that we will have more of them in the coming weeks and months. I hope that we will return to some semblance of normalcy. It has not been a very normal time at the university. So today's public forum is entitled 200 Years of Norwegian Constitution, Reflections on Thai Constitutionalism. I am happy to tell you that we have a good balanced lineup. I'm thankful to all the speakers, particularly Professor Stein, Tønnesson, who's just flown in from abroad, I think from Norway. Yeah, so just got off the plane. He'll give us a presentation on the Norwegian experience in constitutionalism, and then we have a lineup of distinguished experts on the Thai constitutionalism, Dr. Michael Nelson, Dr. Pitch Pongsawat, and particularly Professor Charas Suwanmala, who has been the dean here, and he's also an instrumental member of the organizing committee of the PDRC. So, without further ado, please let me just say that we thank the Norwegian Embassy for working with us on this event, and I'm very happy. At last Thursday there was a reception to celebrate Norway's 200 years of constitutionalism, and also to bid farewell to the eminent ambassador who's made a big difference here, Ambassador Katja. So please, Ambassador Katja, tell us a little bit about the Norwegian experience and your reflections.
Thank you, Professor Titinan. Excellencies, distinguished participants, ladies and gentlemen. I'm very happy to welcome you all to join our open forum here today, dedicated to the 200th anniversary of the Norwegian Constitution. I believe that the topic of Thai constitutionalism is both timely and relevant, and I hope that our deliberations here today may give some inspiration and points of reference to the future discussions on democratic development in Thailand. I'm also very pleased with the lineup of speakers that Dr. Titinan has managed to convene, and I look forward to an interesting debate today. And I'm of course also particularly grateful that Professor Stein Tønnesson from the Peace Research Institute in Oslo has come all the way from Norway to participate in the forum today. So I would like to open the forum by providing, as a backdrop to our discussion, some information about Norway and our democratic development over the last 200 years. The Norwegian Constitution of 17 May 1814 laid the very foundation of democratic development in Norway, and it has proved itself more durable than other constitutions drawn up at the same time in Europe. As Europe's oldest and the world's second oldest prevailing constitution, it is now a unifying symbol of freedom, independence and democracy. And it's a legal instrument upon which we have built our democratic society, based on equality and solidarity. The most important ideas expressed in the constitutions were radical beliefs at the time that had triumphed in the American War of Independence and the French Revolution, such as sovereignty of the people, separation of powers, and civil liberties such as the rule of law, freedom of speech and assembly. And we could say that the modern Norwegian state was founded in 1814. Since then, the political system has been reformed several times to make it even more democratic. And I would like to mention two reforms in particular. In 1837, local self-government was introduced in the municipalities. Nowadays, we have a complex system of strong local self-government. Local issues are decided on the local level by elected local politicians. The income side of local budgets consists of both local income tax and revenues transferred from the central government. And it's a national aim to offer citizens a high level of public services with equal standards wherever they live in the country. Therefore, there is a high degree of redistribution of income between the local authorities. This ensures both a fair distribution of income and regional growth and development, which is essential to maintain an efficient and autonomous local government sector. Having elected local authorities who are accountable and eager to please voters in their districts and who are familiar with local challenges creates a healthy local democracy where people in the local community can feel more in charge of their own destiny. I think this is an interesting aspect that we could also maybe discuss in relation to Thailand. In 1884, parliamentarianism was introduced in Norway. It basically means that the cabinet must not have the parliament against it, and that the appointment of the cabinet by the king is a pure formality. So Norway became a constitutional democracy with majority rule and minority rights. In 1898, all adult men were given the right to vote, and in 1913, all women were enfranchised. Let me then say a few words about the economic side of our democratic development, since I think Professor Tønnesson will focus more on legal issues. Because the Norwegian Constitution paved the way also for economic development and welfare in our society. 100 years ago, Norway were among the poorer countries in Europe, and today it's one of the richest in the world. The difference between then and now is striking. So what happened? Of course, there's no specific recipe or simple solution. Expert talks about the combination of lucky circumstances and the implementation of economic policies based on a mix of market solutions and government interventions. The Economist last year in a special report on the so-called Nordic model suggested, quote, solid institution, foresighted and well-handled natural resource management, redistribution of wealth through high taxes, broad political agreement on social reforms, and emphasis on free education to all. And most importantly, the notion of equality and solidarity, equal opportunities to all, and the belief that we will all be better off if everybody can get their share of the income generated, quote ended. And I think it sums it up fairly well. Another of our lucky features is our geographic situation. We are situated on the edge of civilization on the northern tip of the European continent. We have nice and friendly neighbors, and many of them, like England and Germany, developed ahead of us, so they became rich before us and purchased from us. But there are also many other factors that can explain the high standards of living in Norway, and let me mention a few. One is knowledge. Norwegians are highly educated, and access to education is free and equal. This makes us more able to innovate and be creative, and to adjust when economic circumstances change. 2. Technology. Being highly educated, we have also been able to make use of and develop technology in a way that makes us very productive and in the forefront in areas where we already had natural advantages, like in shipping, hydropower, and the petroleum sector. But it also, of course, helps in other sectors as well. Gender equality. Encouraging women to participate in the production process stimulates the economy by, of course, making available more labor hours and by allowing entrepreneurs to tap into the total pool of talent in our country. In Norway, the arrival of women on the job market greatly increased the nation's capacity. And the prerequisite for that to happen was the emergence of an attitude of gender equality, as well as state-run care for children of working parents, and generous maternity and paternity leave system. Law. There is a rule of law in Norway for businesses as well as private persons. There is equal access to the legal system, and the legal institutions are independent, and there is a high degree of public trust in the judges and the legal system in general. Equity. There is an implicit social contract in Norway between the inhabitants and the nation. It says that if you try your best but fail, or get sick, or otherwise cannot work, you will be taken care of. And the pension system is also inclusive. You will receive a pension no matter what you did during your working life. So there is quite a generous welfare system that has developed over the years. Some say too generous, but that's another discussion. I'd also like to mention the factor of culture, because the sociologist Max Weber pointed to the importance of the so-called Protestant work ethic when understanding the Northern European mentality. This is a culture that instills that people should do their duty and put work before pleasure. Doesn't sound very fun maybe, but it's very productive. And then of course, resource endowment. Norway is fortunate to have many waterfalls, large forests, considerable stocks of fish, and a generous amount of oil and natural gas. Our natural resources have been a blessing, rather than the curse many other resource-rich countries experience. I guess this is because Norway already had a functioning representative democracy with strong institutions when it discovered oil. Its political leaders were accountable to their public and largely free of corruption. This gave Norway a unique starting point, and with all this in place, it has managed to distribute its oil wealth evenly to its citizens throughout the whole country, not only in the capital. All in all, Norway seems to have found a middle way between capitalism and socialism, where an open economy is combined with public investments in human capital, and where competitiveness and welfare can reinforce each other most powerfully. Again, quoting The Economist, they attribute our success to a long tradition of good government which emphasizes not only honesty and transparency, but also consensus and compromise. Again, very important notions, I think. And the quote goes on to say, there are real policy lessons to learn. High investment in human capital, flexibility combined with security, low military spending, high research and development support, and policy emphasis on adopting and promoting new productivity-boosting technologies, and other such government behaviors certainly provide worthy guidance for other states. End of quote. So I guess, to sum up, if a country keeps growing, accumulating, investing, reinvesting, and learning, it will eventually become one to be reckoned with. Norway has not done much that was spectacular for 100 years. Yet it is one of the richest countries in the world today. It has never been a miracle star economy like Japan or South Korea, the envy of the whole world. It has not spurred inventions, nor has it seen particularly big leaps, although the oil boom has been considerable. It has grown steadily and equitably. So in Norway, the pie grew larger each year, and fortunately, each slice was cut even-handedly for each inhabitant. That in turn probably affected the size of the following year's pie. So a core lesson of Norwegian economic policy is that sharing the fruits of prosperity establishes an atmosphere of security, identity and belonging, and ensures that an individual believes in the opportunity to make use of her energy and talents. So instead of fighting over the distribution of the pie, people then cooperate to increase the pie. So Norwegians are even generally willing to pay high taxes because they feel that they get something in return. And there is a high degree of transparency and accountability in all public affairs. So even our royal household must publish its expenses. Norway's constitution of 1814 was built on important values and principles that continue to enjoy broad political consensus today. It is still the basis for the modern and prosperous state Norway is today, where income and gender equality rank among the highest in the world, something which contributes to both social stability and economic success. So with these few words, thanks again to Arjan Titinan and ISIS for hosting today's seminar, and thank you.
I think Norway is a wealthy country, constitutional monarchy. Many of the values and attributes that you mentioned, we aspire to. This is not a direct analogy, but I think there's a lot of food for thought for us. Now, we will have a presentation from Professor Stein, and then we'll have some reflections from the Thai speakers.
Thank you for inviting me here. It's a pleasure really to be here in this room, where I have also attended seminars before. Normally I have been always discussing Asia. This is the first time I speak about Norway, but I'm actually quite enthusiastic about it because I've come directly from the 17th of May celebrations in Oslo, which were quite amazing, with the whole city crowded with children. This is a celebration centered on the schools and the school children, and the schools have been through intensive learning about the Constitution for a long time now. The press has just been full of the Constitution for a long time. Let me start with the year that it all began. 1814, the constitutional moment, the occasion that led to the adoption of this constitution. At that time, Norway had for 400 years been part of the Danish-Norwegian kingdom, so the capital was Copenhagen, and that's where the king was residing. But he bet on the wrong horse in the Napoleonic Wars. He allied Norway, Denmark with Napoleon, and Sweden hired or got a regent who was a former general of Napoleon to fight against Napoleon. So Sweden was on the right side. And Sweden then had these troops marching up against Denmark, and then they told the king of Denmark that you must cede Norway to the Swedish king. And the king of Denmark felt that he had to do that, so he signed a treaty in January, 14th of January 1814, where he ceded Norway to the crown of Sweden. This was seen as a break of his obligations towards his Norwegian subjects, so he also absolved them of their pledge of allegiance to him, which they had made in 1666. And then his cousin, who was a governor in Norway, Danish governor in Norway, Christian Frederick, he organized a Norwegian revolt or rebellion and called a representative assembly together at a place called Eidsvoll, which was a center of events also the day before yesterday. And they sat together and studied the world's constitutions at that time. There were about 200 of them at the time. And that they put together the constitution, which is still the Norwegian constitution, with 110 articles. Relatively short one. And this one was adopted on the 16th to 17th of May, and on the 17th of May, Christian Frederick, the governor, was also elected king of Norway. He served as king until he lost a war against the superior Swedish forces in the summer, and then he abdicated and left for Denmark, and left it to the Norwegians to negotiate with the new regent in Sweden, the Bernadotte, who became Karl Johan, the first king of the Bernadotte dynasty. And he accepted, in fact, the constitution. Some say it's because he had little time, because he wanted to become king of France after the fall of Napoleon. And therefore Norway got this very radical constitution for the time, and it was even accepted by the new king, who was the king both of Sweden and Norway. And then the Norwegians developed a constitutional conservatism, where they defended this constitution against King Karl Johan's attempts to amalgamate Norway and Sweden and get more power. So that's the constitutional moment, how it came about. The next question is how can it have survived for so long? Because of those 200 constitutions that existed at that time, there are only two who survived. It's the American one and it's the Norwegian one. And how can that be? And what is the effect of having such an old constitution? Let me start there by looking at the three main models in a way that we were looking at. It's the American model. This is the world's oldest constitution and still in force, with a very strict division of powers. And the presidential system, of course, it's a republic. Then it's the French one. And the French model is to change constitution each time there is a need for a big change. And you had 5 different republics in that period. First one in 1791, then one in 1848, then one in 1870, which never had a constitution. and then one in 1946, and the one that is still there now is the Fifth Republic from 1958. And in between those republican periods, you had the monarchies, but you had three different royal dynasties that competed to be the monarchical leaders: the Bourbons, the Orleans, and the Bonapartes. So in the Third Republic, they could never agree, so they had a majority, but the republic survived because no one could agree on who should be the monarch. But France had contributed so many ideas that others can utilize because of this tradition of changing constitutions. And then there is the United Kingdom, which is, in a way, I would say, when we say that Norway's constitution is the Europe's oldest, we don't reckon the United Kingdom, and that's because they have no constitutional text. So there isn't any text, but actually it's the archetypical one, because that's the one that their system of governance is so old, and it was the one that was studied by Montesquieu in his Esprit des Lois, where you have this chapter on the English Constitution, which was also one of the sources for those who made the Norwegian Constitution at the time. Now, if you have a really old constitution like Norway has, it's very difficult to modernize it because it has a kind of sacred nature to it. We've just been through an amendment now that I will talk about afterwards, but it's really in many ways old-fashioned. For instance, when you read it, you have the impression that the king is deciding a lot of things, which is not the case any longer. But it was in 1814. The king had quite a lot of powers, although it was a constitutional monarchy. Then, if you have an old constitution, because it has been there a long time, there is also a tendency for it to be inclusive, to be the constitution of everyone. Because all kinds of factions through the ages have had their chance to put some stamp on the constitution, either utilize it or amend it. So it cannot belong to just one faction. It's also, therefore, likely to facilitate domestic peace, because you have been used to it, and everyone can use the constitutional setup to promote their interests, and then they don't need to have a coup or a revolution, because this is simply practical to use. So, again, I ask, how come Norway's constitution became so exceptional? Because, as I said to you, there were 200 constitutions at the time, and 198 have not survived. And of the constitutions that have been adopted since then, also almost all of them have disappeared. There are very few that have survived. And there is one publisher in Norway, Pax. They have published 6 volumes now about constitutions on the occasion of the bicentennial. 6 big volumes, and one is about this question of why do most constitutions fail. And they find their main explanation is that most constitutions are written in an emergency. They are written by one faction that is fighting another faction, and then they adopt a constitution which they try to impose on society. But that does not make the constitution conclusive. And therefore you have this shift from one constitution to the other depending on who has power. But those constitutions that survive are more those that are created by the whole nation. And that's what happened in Norway, because this was a national rebellion against being ceded from one crown to another. And then after that had happened, you got a king who was seen as a foreigner. He was a Frenchman. He was originally a Catholic, and he was trying to get more power in Norway, so you needed to defend the constitution. So a long time the whole nation defended the constitution, and that in a way built into it this survivability. Then the constitution was also radical for its time in that it applied the principle of popular sovereignty. And that was right before you had a reaction in the rest of Europe with more monarchic and conservative constitutions. So that meant that this constitution also spearheaded the later democratic development in the 19th century and was seen as an inspiring model also by other Nordic countries. And Norway, in a way, spearheaded the development towards a more democratic Northern Europe. This is also actually part of the reason why Alfred Nobel, the Swedish magnate and businessman, decided that the Nobel Peace Prize should be awarded by the Norwegian Parliament. It was built on popular sovereignty, both as a new idea that has spread during the Enlightenment and as an old idea, because the absolutist monarchy that had been in Denmark, Norway, had actually also got its power from the people, not from the gods. The gods were there, the god was there to help, but the power came from the people through an oath of allegiance made in 1666. And when the king ceded the country, he broke that agreement from 1666. That's what the people thought, and also his cousin, the governor. So they thought that now the people are free to adopt their own constitution again. Then another part of it is that Norway had no nobility, or it had a little bit of nobility before that, but it was abolished. So only those noblemen who were still alive, they could stay noble for the rest of their lives, but there would be no new nobility. So by contrast to other European countries, Norway had no nobility. And this is part of an egalitarianism, which is also represented in our national anthem, where it says that Norway has huts and houses, but no castles. This egalitarianism actually was also noticed by King Chulalongkorn when he visited Norway in 1907. He stayed with the Norwegian king, who had just become king 2 years before, when the union with Sweden was dissolved. And he liked King Håkon quite a lot, he said in his letters back to his daughter. But he also noted how King Håkon was complaining about the Norwegian egalitarianism, because he could not put up fences around his property. He could not even buy himself a car, because there was fear that the car would scare the horses, and then that would create a bit bad image for the royalty. So King Chulalongkorn was a bit surprised by this kind of king who could not have more power and more prosperity than this king, who had to think about being like the others so much all the time. As Ambassador Katja Nordgaard mentioned, the democracy was very much developed downward through the local democracy and local self-government, through new laws adopted in 1837. This is also part of the Constitution's success, that it was not so detailed. So when you got the law about local democracy, it was not incorporated in the Constitution as such, but it was a special legislation. And this is based on one particularly famous article in the Constitution, which is Article 94. Article 94 is the subject of one of these 6 volumes. And this is an article that simply tells how you adopt laws. So instead of making a detailed constitution, like the ones you have in some other countries, the Norwegian Constitution is short, but it has the prescriptions for how to adopt laws, how to legislate. The division of powers is there, but it's not as strict as in the United States. The executive and the legislative powers are not that divided, but the judiciary is independent. Over the time, parliamentary rule developed. That was not there originally, but it was a hard struggle, which could actually have become a civil war in the 1880s, between a left and a right. And the left wanted to force the ministers appointed by the king to meet in parliament. But they did not want to meet in parliament because they wanted to have calm to run affairs, and they would only depend on legislation and budgets from the parliament. But this was adopted by the Storting, the name of the parliament, the law saying that the ministers had to meet. And in the end they had to bow, and then also the government resigned and the leader of the opposition who had demanded this formed a new government. That change of government in 1884 in a way started the parliamentary principle. But it was not accepted by everyone. It took a long time, and it was actually codified in the Constitution only in 2007. This system with broad representation has allowed one party to dominate Norway for long periods, and it has been the largest since 1935. That is the Labour Party, but it has also lost power sometimes, and it did last year. So now we have a center conservative party, or a conservative party of two parties that have a coalition together. One important aspect of the Constitution is that it is a monarchy, by contrast to all the republics. That was the case from 1814. And when Norway broke out of the union with Sweden, there was a proposal to have a republic, and there was a referendum on it, but there was a very small minority who wanted to have a republic. So Prince Carl from Denmark was taken up to Norway and became King Håkon. He had to change his name to a real Norwegian name. And the kingdom is codified in the Constitution as being hereditary. So the oldest son it was in the beginning, later it has been changed, so it can be the daughter, will take over, and there is no choice of anyone else. But if there is no heir, says the Constitution, then the king can propose to Parliament, and the Parliament can accept or not accept. If it does not accept, then it's up to Parliament to decide who shall be the new king. That's the rule if there should be an emergency in a way concerning the heir. The king's powers then have been progressively reduced. So today, if you read the Constitution, when you read the word king, it actually means the government. It's the Prime Minister and the Prime Minister's government that represents the king, and the king has only the job of sitting there at meetings and signing off on what is being decided. The Constitution says that the king must confess to the evangelical Lutheran faith. And this is actually the latest occasion where we think that the king had a direct influence on political matters. Because in connection with preparations for amending the Constitution before the bicentennial this year, there was also a wish to remove, among politicians, to remove that rule. Because now Norway is a country with people from many religions, a multicultural country, and then it doesn't really make sense that the king, as the head of state, should belong to one particular faith. But when the minister, when the king learned from the minister or from someone that this was in the process of happening, he is rumored, and also it's said in a recent book, to have asked the minister to come to the palace, and he told him that he felt strongly that this needed to continue to be there, that the king should have the evangelical Lutheran faith. Originally this was put in 1814, well knowing that the king of Sweden, the new regent of Sweden who would become king, that he was a French Catholic. And it would prevent him from being king, but that has actually survived until today. Even after the state church has been abolished, this rule about the king remains, and the king really wants to keep it. Of course, the royalty do not really have political importance any longer, except in this matter there. But they are very useful to the country. I think the ambassador recognizes that as well. They often go abroad on visits with Norwegian businessmen, and they function as a kind of top ambassadors for the country. And they are part of an international network, blue-blooded network. And of course the visit by King Chulalongkorn at that time was also part of that. That you have this fraternity or blood fraternity among kings. But the royal family in Norway has moved a little bit away from that through their marriage policy. Because the rule was normally that you should marry other royals. You should marry someone who also had blue blood. But King Harald, he married a commoner, And his son has even married a commoner who already had children from a previous relationship. So this means that the royalty have, in a way, adopted the modern habits of their population, and that has to some extent moved the royalty closer to the people, and it has also, I think, moved the royalty a little bit from the conservative right to the more liberal left. So in the past, republicanism in Norway as a marginal phenomenon was a phenomenon only of the left. The Labour Party has a program saying that they want a republic, but they have not really tried to fight for it because they have liked the king so much. But now we have an upcoming republicanism on the right-hand side, because there are some who think that particularly the Crown Prince and the Crown Princess are taking too much interest in issues like defending homosexuality, for instance, and other values that often belong more to the left side of the political spectrum. So it's an interesting development with republicanism from the right. The franchise in Norway, broad from the beginning. 40% to 40% of all adult men could vote. There were some very complicated rules that I will not go into for who could not vote, but it's important to remember that it was actually restricted. It was not universal suffrage at that time, and that was not usual either. In democracy, part of democratization was to develop universal suffrage. This has been different for countries that have developed democracy later, because in a later period it has been excluded to, in a way, have restricted suffrage. No, the only one I know who has proposed in modern times that one should have anything else than one person, one vote is Lee Kuan Yew, who suggested at one stage that men above 40 with children should have 2 votes. But even in Singapore that was impossible to get accepted by him. Norway got universal suffrage after a long fight for men in 1898 and for women in 1913. 1913 for women, relatively early, before the First World War, but 1898 was not that early. There were several other countries that were earlier than Norway. We have an article in the Constitution that has quite specific prescriptions for how the elections are going to be organized. They are proportional. Then to a question that may interest you. What are the conservative guarantees? What has been done in Norway to try to prevent the majority of the moment from doing things that one might regret later? This has always been a concern of conservative thinkers. There must be something in the Constitution that put brakes on legislation, brakes on decisions, so that you shall not act on that from the moment, but you must really consider what you're doing. One such guarantee was in the royal veto power, which was much discussed in 1814. But it was decided to do the same thing they had done in the French revolutionary constitution and make it just suspensive. So the king could refuse to sign up on a law, but he could only refuse 3 times. And then it would go back to parliament, and if it was decided again and again, then the king would have to bow. And the reason actually why the union broke up in 1905 was that the king refused 3 times to accept that Norway should have its own consuls abroad. And Norway had developed a lot of business interests abroad. And then when he refused the 3rd time, then the Norwegian parliament just decided that now he has ceased to function as Norwegian king because he didn't do his duty to sign off on the law. That created a little crisis, which could have been a war, but thanks to the moderation of the Swedes and the population who resisted the idea of the king to fight a war against Norway, Norway was allowed to break out. So this royal veto power was tested first when parliamentary rule came in 1884, and then when the union was dissolved in 1905. And since then it has not played any role. We have not needed any guarantee in this veto power. Then the next question is one that we will hear from Michael Nelson about afterwards, about the question of the chambers. Because in Norway they discussed, and you know that the United States adopted a system with a House of Representatives and a Senate. Norway had a discussion about that. They decided to have a system with just one election. So the Storting is elected, and the Storting then decides itself who shall be members of the Lagting and who shall be members of the Odelsting. 2/3 in the Odelsting, 1/3 in the Lagting. And when you adopt laws, they have to have a majority in both chambers. And if that does not happen, if the Lagting goes against what the Odelsting decides, then it will go back to the Storting, and then the Storting will need 2/3 majority. This was a system until this Lagting was abolished a few years ago. So now the Lagting does not exist any longer. We have just a pure one-chamber system, unicameral system. So the last time we heard about the Lagting was when the Dalai Lama just visited Norway, because he was meant to visit the Storting and to be received in the Lagting room, which is the second most important room. And then suddenly it was decided that he should not come there because that would not please China. So he had to go to a small room called the cinema instead. This means that there's just one chamber. This was also taken up by King Haakon when he met King Chulalongkorn. So he told King Chulalongkorn first that you should never have a parliament in Thailand at all, because parliaments just make trouble. And that was what the Prime Minister also said, at the Norwegian Prime Minister to King Chulalongkorn. And then if you have a parliament, at least you should have more than one chamber, because if you have just one chamber, then it can be dominated by one party. But we have just one chamber, and it has worked since then, in spite of what King Haakon thought at the time when he spoke with King Chulalongkorn. There is a certain conservative guarantee that is still valid also, and that concerns amendments to the Constitution. You need a 2/3 majority, and you cannot decide it in the same Storting that where it has been proposed. You have to wait till after the next elections. That is a delay that gives time to consider and to negotiate, and makes it actually quite difficult to make amendments. And then finally there is a judicial review by the courts, which is important, so I will return to that. Which were the amendments that we made just now? We've made quite a few amendments over time, but you need each time to have a broad consensus in order to have that 2/3 majority, and in two different Stortings. The amendments that were made now went short of what some people had hoped. They have been prepared for a long time. There have been negotiations about them for 2 consecutive Stortings, and there have been committees working on it. And Tuesday last week, we got the result. We got a modernized language, because the language was from 1903 when the last linguistic change was made. So it reads kind of antiquated, this old constitution. Now it's more modern language. We also got a version of the constitution in the other Norwegian language. You may perhaps be surprised that a country of 5 million has 2 written languages, but we do. So Nynorsk, the new Norwegian as it's called, has also got the constitution now in its own language. We got some new civil and political rights codified in the constitution: equality before the law, right to a fair trial. We got prohibition against the death penalty in the constitution, also against torture and inhumane treatment. And very importantly, for the first time in the Constitution, it says that the courts have a right to review legislation. So this is perhaps the most important legal change, although in practice it has actually been there since before 1860. The courts have been able to review legislation and administrative decisions already before, but now this has become part of the Constitution. And this is important because also legislation has developed on the European level that affects Norway, so that there is now a kind of competition between the Norwegian Supreme Court and the government's interpretation of our obligations towards the European Union as members of the European Economic Area, and also the European Court of Human Rights. So this is important and has also created a discussion about this development internationally in Europe, where we are actually ceding part of our sovereignty to the European level. It has happened now at least twice in important cases that something that had been decided in Norway was overruled because it conflicted with human rights obligations or with the legislation in Europe. And although Norway is not a member of the European Union, we are still obliged through our treaty that gives us access to the internal market to adopt most of the European legislation. And this has put in a way power out of the country and reduced this, perhaps some say that it has reversed the trend of democratization. So this is a major question that is being discussed at the moment. I'm approaching the end, and the question of human rights was a big thing now for this amendment, because actually on human rights the Norwegian Constitution is not that strong. The human rights are scattered, and Norway has more obligations towards human rights through the international treaties that Norway has ratified than it has in the Constitution. From the beginning there was freedom of the press, there was protection of property, private property, and it was clear that rights could also be actioned through the courts. The courts could defend the rights against the state. But the Constitution was not at all imbued with the same kind of human rights thinking that you had in the declarations of human rights in France and the United States. It was much about the state's duties, and this has also characterized what has been added later, like the state's obligation to promote minority language, culture and social life of the Sami population in the north, a different ethnic group, and also the state's obligation to make possible for everyone to make a living from their work. But now, in the latest amendment, there was an attempt to create a whole human rights chapter that would be make the Norwegian Constitution more to conform better with Norway's treaty obligations. But that did not work out completely. It worked out in some way because there were some new amendments, like the ones I mentioned, some new rights added. But the conservative side did not want to include the economic and social rights, because they say that why should we have rights defined in the Constitution that are not actionable in the courts? Because to provide health and education to people, that's a budgetary matter. It's not the matter of rights. How can you have a court prosecute the state for not having given education if they don't have the money for it? That was the argument, or at least part of the argument. So the left-hand side of the political spectrum wanted this and didn't get it. They also wanted to have constitutional protection of the Sami minority, and that did not work out, but there is from before this duty to promote their language and culture. And then there was also a minority wish to define the family as the core of society. And one thought for a moment, until last Monday I think, one thought that this would actually succeed, because the Christian Democratic parties' votes were needed for some of the others, and then they would in return get this family principle. But it didn't work out in the end, so the family did not get in. So still today it's not the family but the individual that is the basis of society in Norway. So we did not get all the amendments one tried, but we got, as I told you, a hugely successful celebration with lots of happy school children on the 17th of May, and that's why you've heard me being so enthusiastic. So thanks for listening.